First on 4029, a measure aimed at expanding abortion rights in Arkansas will not be on the November ballot.
We were the first to tell you through a breaking news alert about the state Supreme Court ruling that came down this morning regarding the filing process.
4029's Brett Rains is in Fort Smith and talked to the Secretary of State, the Attorney General, and those fighting to let voters decide the issue.
In a 4-3 split decision, the Arkansas Supreme Court ruled that the Secretary of State followed the law by rejecting the entire abortion ballot measure over filing documents. But supporters of the measure say they do not feel like they were treated equally.
But it's a dark day, in my opinion, for women in the state who want and need access to safe standard of care, health care, and, deserve the autonomy, right, to make decisions about their bodies without interference from the government.
Arkansans for Limited Government was seeking to let voters decide on expanding abortion rights in Arkansas. If approved, the measure would prevent the state from restricting access to abortion up to 18 weeks post-fertilization or approximately 20 weeks of gestation, as well as in instances of rape or incest, fatal fetal anomaly, or when abortion is needed to protect the woman's life or physical health. Right now, abortion is only allowed in Arkansas if the mother's life is in danger. But now, the measure will not be on the ballot after a majority of Supreme Court justices ruled that the group did not follow the law when officially filing the signed petitions. The majority opinion says lists of paid canvassers and training certifications were submitted beforehand, but not when the group submitted the actual petitions. The majority found that all of the documents were supposed to be submitted together when filed with the Secretary of State's office. We asked Secretary of State John Thurston about it.
It's the final step of the entire process. This thing's not piecemealed, right? The thing's not complete until filing.
We feel very strongly that this ruling is basically a silencing of 102,000 voters who wanted to make their voice heard on this issue and who signed the petition. We still believe that all the information that the Secretary of State needed from us, he had.
Rebecca Barbaro is with Arkansans for Limited Government.
It is very frustrating to feel that our petition is being treated differently than a couple of the other ballot initiatives.
The decision that was made by the staff, myself, was not politically motivated, that we sincerely were doing our best to fulfill our responsibility.
But the law's clear. I love how people, when they screw up on the law, they just start looking for somebody to blame. I'd like to get them a mirror.
As for the other issues, the casino amendment ballot measure requiring local county voters to approve issuing any new casino license will be on the ballot. And right now, those who are trying to expand medical marijuana access across the state have until the end of the month to gather more signatures in order to make the ballot. Arkansas Attorney General Tim Griffin says the legal issues with the abortion measure were due to paid canvasser training, where the marijuana issue was over background checks for paid canvassers.
It wasn't too complicated for the casino folks as it relates to 111 F2B. Wasn't too complicated for the marijuana folks. The abortion folks just couldn't get there. So to act as if no one could understand this, well, that's nonsense.
And while the abortion measure will not be on November ballots, supporters say they're not going away and they'll keep trying to get the issue before voters to let them decide. More on that tonight at 6. In Fort Smith, Brett Rains, 4029 News.
A first